No, good.
Looks like they need your help. Well, now on the third one, they can't figure it out. Don't look at me, I ain't gonna even attempt to help.
We set it down a while ago, it was live, and now it's.
Turn that one off and let's see if that makes it. I don't think it will.
It still works.
Hold on. Turn it.
Save my phone. They're working on new batteries. Okay. Sorry about the, get through meeting, sir. We will now call this public hearing to order. Public hearing is for the benefit of the board of directors and the public. We appreciate everybody coming out today, and I will turn it over to you.
Well, I want to introduce the four men just immediately to my right. Introduce myself first. I'm not normally used to that, but I will. Thank you, Brian. My name is Jim Conkride. I'm the general manager of the Prairielands Groundwater Conservation District. And echo our president's appreciation for each of you being in attendance today, for each of you having an interest in the groundwater resources of the 4 counties in our jurisdiction. To my right, my immediate right, the first 4 men comprised the Rules and Bylaws Committee. There's 1 board member from each county on that committee. Our president, Charles Becerra, Paul Tischler, Randy, Kirk, and Marty McPherson. And they represent all 4, each one of our counties. So they have worked long and hard for 2 years on these rules, and the last year has been extremely busy with a lot of meetings and a lot of input from our constituents. On the far end is another board member, Maurice Osborne from over in Ellis County. And then to my left, starting over here, is Kent Smith and Todd Sandling. They're also board members. One of our board members, Dennis Aronakis, was ill today and probably won't attend. Said if he got to feeling better, he would. To my immediate left is our legal counsel, our attorney, Brian Sledge. Our hydrogeologist is James Beach of WSP, and he is seated on this front row, and he will be a part of the presentation that you will see. I appreciate the staff members that are here that have helped get this together and worked diligently for a long time. Stephanie Rexroad, Rosetta Douthat, Michael Heath, and Karen Segal. I think I saw Karen. Yeah, she's in the 3rd row there. So, thanks to those people. If you have one of these with you, we would ask at this time that you move it to silent or vibrate so it won't disturb the hearing and the meeting once we get started. But again, thank you for being here. And according to our agenda, looks like we're up for the presentation by Brian Sledge and James Beach.
Well, good morning. James, you got the slide change?
Got it.
Some preliminary matters first. This is a rulemaking hearing under section 36.101 of the Water Code. And I'll note for the record that the meeting is being recorded and that notice has been provided in accordance with that section of the Water Code and of the Open Meetings Act. We have a sign-in sheet at the back on the table that you may have seen. If you intend to provide comments, we need you to sign in. We'd like to know you were here, and that's the only way we're going to be able to recognize you to call you up. So please sign that if you haven't and indicate whether you do or do not want to testify after this presentation, we'll have a formal public comment period, which is being audio recorded. And we'll ask you to come up and use the microphone so we can capture the comments on the audio recording. And we'll have an informal Q&A after that, in case you have any questions. And with no further ado, we'll start in on this. And I'm going to tag team with James Beach of WSP, our district hydrogeologist. Let him cover the technical stuff, and I'll try to focus on the legal issues. A brief overview, and many of you have seen this. We've had a number of public meetings on the rules already. We've had a number of stakeholder meetings. We've met with a lot of you individually, and you're not going to hear much new here today if you've been part of all that, but we'll regurgitate it anyway. Prairielands Groundwater District was created by the Texas Legislature in 2009 in Ellis, Hill, Johnson, and Somerville counties after the Texas Commission on Environmental Quality, TCQ, designated this region and all the counties basically from the Red River down to the Colorado River over the Trinity and Woodbine Aquifer as a priority groundwater management area. And that designation means that you're either already experiencing or expected to experience critical groundwater problems in the next 25 years. After TCQ made that designation, the way the law works is that there's a 2-year window, and that 2-year period coincides with the legislative cycle to allow the legislature to create a groundwater district. And if you don't create one, the TCQ will create one for you under the law. And so a number of the counties between, I guess, Temple, Bell County, and all the way up to the Red River got together and worked with their legislators to create groundwater conservation districts. Our prior focus, since we were created in 2009, has been primarily on developing good science and gathering data, and James can talk about that, but we weren't satisfied with the level of the science that was available in Austin. We spent several $1 million working cooperatively with other districts in the region to pull together the best science we could and that was available on the groundwater resources in the area, and developed a groundwater availability model that was later adopted by the Water Development Board and replaced the old model they had, and pretty much is held out by them as the best groundwater availability model in the state. A lot of information and site-specific well data went into developing that. And we also adopted temporary rules in 2009, and many of y'all who have well registrations under our temporary rules are familiar with those. But we are required by the legislature to develop permanent rules and a permitting system, and that's why we're here today. And James is going to go over the planning goals for the aquifers that are set on a 50-year basis. What do we want the aquifers to look like in 50 years? But in the big picture of things, we're required to adopt a permitting system that will achieve those planning goals. And with that, James, I think I'll turn it over to you. I think we go into the technical stuff.
Yeah. Do I need to use this? My name is James Beach with WSP. Some of you may remember the former firm's name, LBG Guyton. We're groundwater consultants, and I'm here to speak mainly to the technical issues, hydrogeology, groundwater issues, and just kind of give you a brief overview of the hydrogeology of the district, some of the issues that the board has had to deal with in trying to develop permanent rules. And the first thing is just kind of where we sit geographically. There's the outline of the 4 counties in Prairielands GCD, and those 4 counties basically overlie the Trinity Aquifer. The minor aquifer is the Woodbine Aquifer. It's not shown on this map, but it also covers part of those 4 counties as well. The reason that I wanted to start there is because Brian had mentioned that the TCEQ had gone through a an assessment of aquifers and impact on aquifers over the past 100 years in the Trinity. And what they came up with was looking at total water level declines in the major aquifers, and this is in the Trinity Aquifer, and you can see where Prairielands falls in that assessment. Now, those total water level declines in this case are generally in the Hensel and Austin Aquifer, and that basically, without going through all of the numbers there, it's over 800 foot in those most red areas there. And so parts of Prairielands, the northern portion, Austin Aquifer generally, you see some pretty significant drawdowns, but overall you see some fairly significant drawdowns in the Hensel and Austin. And that is why, as Brian indicated, the TCEQ and then the district has followed up with trying to implement appropriate rules for aquifer management. So one of the things that most of you know if you operate wells in the Trinity or even the Woodbine is that there's a big difference from west to east depending on where you're at in the aquifer. This is a very simple schematic looking at confined versus unconfined portions of the aquifer. Many of you in Hill and Ellis County operate wells that are very deep and they're confined, and so when you pump those wells, you get quite a bit of drawdown. And over the years, as we saw in the previous map, you see that there can be several of hundreds of feet of drawdown, in some cases up to 600 or 800 foot of drawdown in some of those wells. So that's what happens on the east side of the district in some of those deeper units, and on the west side of the district, those same units come up, they're shallower, they can be even unconfined. The wells are shallower, they have smaller screen intervals. When you pump them, they respond differently compared to what they would on the east side. You don't have as much available drawdown in those wells. You might have 50 or 100 foot of drawdown as opposed to, or of available water level change in a well compared to the east side of the district where you might have 1,000 or 1,500 foot of available drawdown or water above the actual aquifer that you're pumping. So a little bit more true to the complex nature of the aquifers is shown here, where we're going from Somerville County on the west to the eastern side of Hill County there. And you can see that those major aquifers, Hensel, Austin, Glen Rose, and then Woodbine is that little blue layer up there on the eastern side of Hill County. You can see how they dip over space to the east as you move to the east, and then you can see that there's faulting in there. There's some complexity of changes with those aquifers. You know, if you just move 20 miles east or west, you've got a lot of different depths. You've got a lot of different productivity in those wells as well. So if you look historically, and this is some of the particular water level data in wells that add to describing that map we looked at earlier, where you've kind of got that red bullseye in and around Dallas and south in Prairielands area. What you see here, for instance, is a Woodbine well in this one happens to be in the eastern part of Johnson County, and you can see those water level declines. This hydrograph runs from about 70 all the way through 2010. And what we've shown on this map also is just the screen interval in the well, which is defined by that blue line, and then the total depth of the well there is shown by the dotted black line. So you can see that the water levels have changed. And in this case, we're talking about 40, 50 foot of water level change, but you've gone from a condition where water levels are higher and above the screened interval to a condition where you've now got water levels below the top of the screen, and those wells, as some of the board members have also very familiar with, those wells aren't producing what they used to because they don't have that driving head and the pressure in the aquifer to kind of push water to them. They're still producing water, but they're not producing water at the same rate they were back when they were drilled in the 60s or 70s. And so that's one example. Another example here in the Woodbine, this one's over in Ellis County, and you can see there the water levels, the total, that we don't have screen information on this well, the screen intervals, excuse me. But you can see that the water levels have dropped about 120 foot over the same time period. And so you can see that you're closer to, the water levels are closer to the total depth of the base of the well than they were back in the 60s. And again, all of this is just to show some site-specific well information in some of these areas that go into that bigger map that you saw earlier. And again, here, this is a Paluxy well in Johnson County, going from 175 down to about 75. So we got about 100 foot of water level decline there. You can see that it's getting pretty close to the screen interval there over time. Here's Hensel in Hill County, a Hensel well in Hill County there. We're seeing about 250, 300 foot of water level decline over time. Now, the good news about these wells like this is that you've got quite a bit of available drawdown. So your water level's at 200 foot above mean sea level, but your depth there is 550. And so you've still got some available drawdown in that well. You're not going to be going dry in those wells immediately or in the near future, but long-term management, if you just look at the level of decline in that well over the past 40 years, you can imagine that if you keep pumping it the same way, you're going to have continued water level decline and potentially some reduced production, etc. So that speaks to sort of the bigger issue of addressing aquifer management, water level declines. So here's the last one, I think, is here in the Austin, and that one's in the outcrop close to Somervell County. And there you can see we've got water level declines again, about 250, 300 foot. And you can see that it's, we've gone basically from almost land surface with the water level to, halfway to the total depth of the well. So again there, we don't have specifics on that particular well of the screened interval, but you can see the water level decline through time. So all of that leads to the discussion of how you manage that, and what the state has put in place to help do that is groundwater management areas, GMAs. And so we'll try not to throw too many acronyms out, but GMA is basically just a geographic area that is somewhat suitable for managing an aquifer. And in this case, we're talking about the Trinity, and then the Woodbine gets combined into that as a minor aquifer. They've designated, the Water Development Board has designated 16 different regions across the state. You happen to be in GMA 8, and that is shown here in a little bit more detail. You can see the groundwater conservation districts. Brian had mentioned earlier about the work and all the effort, the money that has been spent to develop good science and the best science we can in this area, the GMA 8 area being outlined in red, and then the districts inside the area there, and you can see Prairielands right in the middle. And all of these districts have come together over the last decade basically to invest money to get the best science, the best data, put all of that into a groundwater availability model, which is a tool which is used to look at long-term water level declines under various pumping scenarios. And so that's the outline of GMA 8. And then the GCDs, the groundwater conservation districts, in this case, you're looking at Prairielands here, they are responsible, as laid out in Chapter 36, to define the desired future conditions. And so essentially, that is a quantitative description of where you want the aquifers to be in 50 years or sometime in the future. And so in this case, that may look like a particular water level decline in each aquifer, and it helps guide management of the aquifer over the long term. It doesn't, it flows into the rules that are generated and the rules that are being proposed today. And Brian will get into more of that later as he talks about the nitty-gritty of how to allocate water and why why the board chose to propose what they're proposing today. And then the GMAs, these groundwater management areas, basically utilize the groundwater availability models to do the best they can to predict, okay, if we want the aquifers to end up at this point in the future at some potential water level decline through time, then this is what we can pump out of those aquifers to get there. And so that's sort of the projection forward that we do with the model, and every one of the GCDs, including Prairielands, is a part of that discussion through the joint planning process. Now, the things that are factors in that decision as to what to project long-term and how much pumping to allow long-term are the things that you see here. The desired future conditions are the requirement in Chapter 36 is that all 9, let's see, in here we've got, 9 things that are listed, including the things we've already been talking about in this presentation: the aquifer conditions, water levels, water supply needs, hydrogeologic conditions, environmental impacts, impacts on subsidence. Thank goodness you don't have a big issue there in this area with subsidence, socioeconomic impacts. One of the things that we've done, I don't go into it in great detail here, but as an example, one of the things that we did in regards to socioeconomic impacts was look, and it ties together with hydrogeologic conditions, water supply needs. One of the things that the board spent a lot of time with over the last few years and in the GMA process was looking at potential pumping scenarios and how that plays into water level decline in existing public water supply wells. And so those public water supply wells are impacted differently if you pump a lot versus if you pump about what you've been pumping versus if you pump less than what you have been pumping. And so they looked at all of those scenarios. They looked at impact on public water supply wells because it has a big impact on socioeconomic conditions, right? And so that was one of the examples of how they looked at those things. That obviously also ties together with aquifer uses and conditions, et cetera. A big concern about private property rights, and Brian will get more into that later. Just the feasibility of achieving this desired future condition. Is it even possible? Is it something that makes sense for all of the users of the aquifer as well as for the management scenarios, and then any other relevant information that comes into play. So those are the factors that go into determining this long-term desired future condition in the aquifer. So as this modeling is done, as the tool is used to assess impacts in the aquifer, what happens is the model is run and we look at impacts to the aquifers, okay? And you can do kind of a what if, a cause and effect type of scenarios, and the conditions that exist in the aquifer in all 4 counties. Now, we went through a lot of iterations with different model runs, what we call model runs, where we look at more pumping, less pumping, what's been pumped in the past, if we just carry that forward, if we pump less than that in the future, if we pump more than that, and across the district, the goal was to try to maintain a reasonable aquifer condition in the future that allows for the appropriate use of the aquifer as well. And that's a general way of saying kind of what the overall goal was. But what you're looking at here is a pretty complicated table which shows the average drawdown in each aquifer in each county as calculated by the model. And then over there in the red, in that column, you can see across all 4 counties in the district what the average drawdown is predicted, or the desired future condition for the aquifer in the 4 counties. And so you can also see in the most right-hand column over there, for all of the groundwater management area 8, you can see what the drawdowns were predicted in each one of the aquifers. So, for instance, in the Houston, if you look at the very bottom, the 50-year prediction is to have 289 feet of future water level decline above and beyond what we have right now. in the Austin Aquifer. In the Woodbine, 39 feet. So that's the numbers basically come out of this long modeling process where we look at a lot of different pumping scenarios, and those are the desired future conditions. So because we've got a good model, and there's been a lot of work done in that regard, the Water Development Board can take the model, take those drawdown conditions, and basically come up with what's called a model available groundwater. And what that is a calculation of the volume of water that can be pumped from each one of those aquifers, given the desired future conditions or the water level decline that has been adopted. And so that's what the Water Development Board does. The MAG is a number that basically tells you, okay, if you want to end up at this target level, then the tool tells us that you can pump about this much from each one of the aquifers. Now, that's it's a projection, it's a forecast, it's done with the best available science, the best tool we have, but we also know that it's our best estimate. And so the model available groundwater is used for planning purposes by the regional water planning groups, and the Water Development Board requires that model available groundwater, that bucket of water from each aquifer, that's the number that's used in the regional water planning. And so the regional water planning groups, when they're looking at all of the cities in Prairielands, when they're looking at all the cities in GMA 8 and everybody who needs water, mining, livestock, oil and gas, municipalities, there's 6 different water user groups that they plan for. They can't come and use more than that number right there. And that helps the district to maintain a planning objective for the aquifers, okay? Nobody's going to overutilize the aquifer, at least in regional water planning. It says that if the water's not available in the aquifer, then if you've got a need for a city, if you've got a need for whatever the use is, livestock, oil and gas, whatever the case might be, that if it's not available from the aquifer, then it needs to be met by something else. Maybe it's a pipeline from some reservoir somewhere. Maybe it's developing another source of water from some other strategy. But that's what that model available groundwater is used for, and the district, knowing that the model available groundwater, the MAG, is just an estimate. The goal is to, and the requirement by law, and Brian will talk to you about this more, but they're required to meet the desired future conditions and to track the desired future conditions and say that's what we're shooting for. And so the MAG is not necessarily a cap on permitting or anything else. It's a guideline to use for the district to use as another data point, another tool in the management of the aquifer. So if we look at what those availabilities are by county or across the district as a whole, and then by aquifer, you can see the annual availability in gallons per year. And so what you'll see there is that those are really big numbers if you look at them in gallons per year. If you break that down to gallons per acre or a reasonable size number on any tract of land, it becomes a lot smaller number because we're talking about a 4-county area here. And so that's one of the things that the district and the board members had to wrestle with as they look forward to trying to manage pumping from the aquifer and impacts on the aquifer, is that those are big numbers, but yet when you look at them on a tract size level, sometimes they look pretty small. So anyway, we'll go into, Brian can get more into that as he steps through the rules. And I think at this point, I'm going to turn it back to Brian and he can talk more about the timeline. Go from there.
Thank you, James. All right. See if I can figure out how to operate this thing. I'm an Aggie, but after Saturday night, I have a lot more confidence as an Aggie than I used to. So, James gave a good overview of kind of the technical situation facing the board as we went into the development of rules. And again, here's kind of a timeline of what the district's been focused on, generally speaking. I kind of hit that on the front end, so I won't do it. But the real thing is once we got the desired future conditions in 2017, and the Water Development Board generated those groundwater availability numbers for us in 2018, the next step under the law was for us to adopt a permitting system, which is what we're here today to do. So the way rules are structured for groundwater conservation districts under Chapter 36, basically the legislature provides district with a toolbox of different regulatory tools that it can choose from in how it wants to manage the groundwater resources. You don't have to use all the tools. You can use a combination of the tools. The real thing that the legislature requires you to do, as James noted, is achieve the desired future conditions. And so, as James noted, while that annual MAG number, that groundwater availability number, is not a total cap on permitting, it is a guideline for the average amount of pumping that we should allow per layer if we want to achieve the desired future conditions, which is what the legislature requires for us. So, well registrations, well spacing, how to allocate groundwater, what types of permits to issue, exemptions to permits, production reporting, getting information from water well drillers and completion logs, limits on total production, and water quality protection by well capping and plugging programs are kind of the general tools available in the toolbox. Our board's goals in rules development were: one, to comply with the law; two, to tailor the rules to the situation of these 4 counties. What works in some parts of the state may not work here. We wanted to cause the least disruption possible to well owners and to continued economic growth. We wanted to protect the private property rights of existing well owners and future well owners. And we didn't want to get to any point where we had to put permits or meters or pumping fees on people's household wells. We wanted to address that through our minimum tract size requirements. And we think we've gotten there with those goals. The big question, and the toughest question, I think, in developing rules and a permitting system is how to allocate out groundwater. There's a number of ways to do it, but there are a finite number of ways. Traditionally, the West Texas approach has been based exclusively on how much land you owned or leased around the well site. Some people call that correlative rights or surface acreage-based correlative rights. And in an agricultural-based economy where people are irrigating a certain number of acres based on how many acres they have in production, that makes a whole lot of sense. The Supreme Court came along in 2012 in the Edwards Aquifer Authority versus Day case and held, one, that landowners own the groundwater as a real property right in place under their land, and that each are to be afforded a fair share of that groundwater. But the Supreme Court also said that groundwater districts must consider issues other than just surface acreage in managing groundwater and ensuring that everybody has their fair share. The Supreme Court said that we've got to take into account historic use, future needs, the relative importance of various uses, environmental impacts, subsidence issues, and the like. And we're supposed to balance all of that and coming up with a system of groundwater allocation that complies with the law. We don't think that regulations based only on surface acreage would work in our area. Prairielands District is a lot more urban than suburban, with a lot of growth coming out of the Metroplex in some areas. There's very few large tracts of land in our water demand centers, dealing with hundreds of thousands of landowners, and there's a potential for being able to be unable to secure necessary acreage contiguous to well sites, especially for our public water systems that are serving in urban and suburban neighborhoods. even if costs weren't an issue, you can imagine, I'm here from the government and I need your groundwater rights. And a lot of our public water systems aren't just overflowing with revenues. And if they did go lease up those rights from the people, who would pay it? It would be the same people they were serving, because the only way to recover that's through their water rates. And going through that exercise, with all the real estate transactional costs that would be associated with it, is not something we thought would be very well received. And the biggest problem is that the good Lord hasn't blessed us with just a whole lot of groundwater resources in this area, at least compared to the amount of demand that's on it in 2018 and beyond. As we look at those numbers that James had on the board for groundwater availability, it's much, much smaller than it is in other areas of the state. I can barely see that, but if you take the numbers, the third to the right column there is the same column that James had up on the board. When we look at the total area of land over each of the aquifers in acres, which is in the third column from the left, and divide those two numbers, we end up with an annual availability in the far right-hand column of not a lot of gallons per acre over the aquifer each year. Looking at 1,285 on the Woodbine, lower in some of the middle formations, and all the way down to 2,318 gallons per acre per year in the hostel. That's not a whole lot of groundwater. That's folks typically use more per acre than that, and obviously that's not something that can continue into the future. So one of the options that has been recognized by both the legislature and the Supreme Court is to protect historic users. And the board has chosen to include that option in our rules. And basically the way that works is that we've set an existing and historic use period over the last 15 years. And those folks with large wells, because we don't require permits still for any type of household well, domestic or livestock well, or anything smaller than 17.36 gallons a minute, which is the same thing as 25,000 gallons per day going forward. So this is really dealing with the larger wells. And when I say dealing with larger wells, while there are a lot of larger wells out there, we really only have maybe a dozen or less of these drilled in all 4 counties per year. So it's not a whole lot of big wells out there still being drilled. But folks can come in and file a permit application for historic use permit, which is based on their maximum year of use during the last 15 years. Regardless of the acreage owned or leased by the permit applicant. In looking at the numbers that James went over and the desired future condition, the good news is that our groundwater budget, based on our estimates, will accommodate not only all the historic use that's out there today, but with some room to grow on groundwater. I guess we've been drilling water wells here for about the last 110, 120 years, and we can protect the current historic level, plus have about 30% more than that budget that's accrued over the last century, additionally for growth. But state law does not provide end-all be-all protections to historic users. There's a limit to how much you can protect them, because you also have to make way for the landowners who have not yet drilled a well and aren't exercising their property rights for that. And so what the law provides is that for any growth by historic users in groundwater, they have to be treated exactly the same as new users who haven't drilled a well yet. And so the way that the board is proposing to address that is based on the surface acreage owned or controlled or leased around the water water well, and that'll be through an operating permit. And so somebody who's never drilled a well, coming in for the first time, after the adoption of these rules, they would apply for an operating permit because they have no historic use, and that would be based on the number of acres they have over the aquifer around the well site. For historic users, they get a historic use permit for the use, but if they want to increase, they come in and they get an operating permit just like any other new user, based again on the surface acreage owned or controlled around the water. It's challenging with the numbers we saw because, as we saw, depending on the specific aquifer, you get about 300 to 400 gallons per acre in the Glen Rose, up to 2,000 to 3,000 in the Hoston. We're proposing to increase that up to 25,000 gallons per acre initially, and at some point in the future, we have to cut back production to achieve the desired future conditions as required by the legislature. We would ratchet that 25,000 gallons back down to the true groundwater availability per acre number, depending on what formation you are in. We're utilizing a provision in the water code that allows us to give retail public utilities consideration for the surface acreage within their CCNs or within their political subdivision boundaries. We will allow those retail public utilities to get credit under a permit for the acreage in their CCN, so long as an individual landowner has not applied for a permit for that acreage. And if at any point in time a landowner does come in and apply for a permit for their acreage, that acreage will be taken out of the retail public utilities column and assigned to that landowner. And so when we issue permits to retail public utilities, First they got their historic use permit, assuming they have historic use. If they have an operating permit, that permit would be based upon the acreage within their CCN or within their political subdivision boundaries, multiplied by the 25,000 gallons per acre, and subtracting out the amount of their historic use permit and the amount of any individual landowner's permits and their associated acreage within that CCN. And that's an ongoing deal. Every time we're proposing 5-year permits, 5-year renewable permits, anytime a retail public utility came in for a renewal of their permit, if individual landowners had come in during that 5-year period and gotten their own permit, we'll take that acreage out of the retail public utilities acreage or out of their permit whenever they come up for renewal. And there's a reason we're pursuing that, because that's how the district looks as far as public water suppliers. These are the retail public water, CCN. CCN, I shouldn't use acronyms, is the Certificate of Convenience and Necessity. That is an approval authorized by the Public Utility Commission that places not only the right for a particular retail public utility to provide public water service within their CCN, within a specified area, but also a duty to provide water to the landowners in that CCN. And so our 4 counties, save except Somerville, the other 3 counties are really heavily covered with CCNs by public water supply. Again, as I just noted, if we have to make cutbacks in the future to achieve the DFCs, we would first apply those against that 25,000 gallon per acre. We would ratchet that back down to a level necessary to achieve the DFCs, but never below the actual scientific amount that the budget says you're entitled to per surface acre. That would be a guaranteed minimum for all landowners. And James, you fixing to be back up here. The other big thing we've got is well spacing rules, and I'm going to let James explain this because it's really a hydrogeology matter to keep people from interfering with each other's wells, and he can do that better than I can.
All right, the last few slides here. So, well spacing rules, the attempt is to, as Brian said, keep one well from interfering with another well inappropriately or to have too much impact on another well. And when we keep those wells spaced appropriately, then there's always some impact, one well to another in a reasonable distance, but we keep it at a impact that is not harmful. And so high volume wells are going to obviously have the most impact, and that's where the rules are focused. For domestic and smaller volume wells, the impact is less, and the rules are more relaxed there. Well spacing is not intended to manage the entire aquifer or to manage the overall volume of water taken from the aquifer. It's basically just meant to avoid unnecessary impact one well to another. And schematically, this is obviously not mathematically correct, but schematically, just to show impacts one well on another. If you have the well on the left pumping, it has a immediate drawdown or a cone of depression around it, and so it's more right around the well. It's less as you move away from the well, and then so that's the impact from that well. And then when you turn on the other well and it starts pumping, it has an impact of its own, shown by the green line, a similar impact, more around the well, less at distance. And then when you add those up, they add together. And as you add more wells in a particular area, those cones of depression start to stack up, and you get more and more impact on each well from the other wells around there. And so the resulting cone of depression from multiple wells continues to add and add and add. So what we try to do with well spacing rules is make sure that we come up with an approach that that limits that impact. And so number one, existing wells are grandfathered. Minimum tract size is still 2 acres. And on a county by county basis, that varies a little bit, but we use a simple well spacing for small household domestic wells of 50 foot from the property line, and that's what I was just talking about. For small wells that are unpermitted, it's a pretty simple rule. For larger wells, we've got a formula based on an aquifer quantitative aquifer drawdown equation called the Cooper-Jacob equation, formula, and basically it allows for a certain amount of drawdown one well to another, to the closest existing well, and that will help minimize the impact of new wells on existing wells. And the parameters used for that spacing can come either from local properties and well tests or from the Trinity GAM in the area. So that's where we'll get the properties for those well spacing requirements, and I guess that's it for now. I'm going to turn this back over to Jim. I'm not sure how you want to handle questions or comments, but that's all of our purpose.
Okay. You've heard the presentation of the district by its consultants and representatives. So we have a number of people who do indicate they want to speak today. Now, all the comments we have received prior to this morning have been provided to the board. So they have copies of the comments. And in no particular order, and I believe these are limited to 3 minutes. So we ask that you restrict your comments to 3 minutes. And we will start with Peter Schulmeyer of Collier Consulting.
And we'll note that if you submitted written comments, we have got those, and those have all been distributed to the board. Peter made me think of that. But go ahead.
want me to speak loudly?
Let's just take this one.
Just have this one.
Good morning. I'm Pete Schulmeyer, Senior Hydrogeologist for Collier Consulting, and I just want to comment on your rules that in the pumping, the maximum pumping rate that you are suggesting at 17.36 gallons per minute equates to 25,000 gallons per day for a landowner. Limiting CCNs to their acreage at 25,000 gallons per year does not allow for fair and equal share for individuals. Individual landowners who can't afford large acreages still are allowed a fair share to the water underneath their property. And limiting them to 25,000 gallons per year through a CCN only equates to about 2% of what a larger landowner is allowed. So you may want to reconsider that. I know our client, Aqua Texas, has commented to us that limiting them to that 25,000 gallons per acre per year may limit them and prevent them from providing service in the future to CCNs. So, thank you.
And next is Rebecca Williams.
Oh, I didn't have a question. I decided because I thought I was supposed to.
Oh, I see you say no. I'm sorry, Rebecca.
I've enjoyed it.
Connie Bradley, do you want to speak? Okay. Terry Kelly?
Just stand here and talk to the group here because it's really more for them. I'm Terry Kelly. I manage the Johnson County Special Utility District, which probably represents maybe the largest public water supplier in the Prairielands Groundwater District. And I appreciate all the work that the board members and all these professionals have done on behalf of everybody in the four-county area. It's a daunting task, and it was 9 years ago whenever they created the district and trying to figure out the science and what's going on underneath us and so far down and how much water is available and for how many years. And one thing's for certain is we continue to grow year after year. We can't stop the growth. You know, we've got to just find a way to deal with it. But as a public water supplier and trying to be a good steward, I have confidence in these guys that they're doing the same thing. We've got directors that represent their respective water supply districts or their water suppliers also. So trying with the rules that we have in place here that they're presenting and proposing today, I think offers the best opportunity for our rural community, you know, for those areas in the district that are not cities or non-municipal areas there. We've got to find a way to work it out where all of our private owners can have their share, and also for these water supply corporations and suppliers that have been around for 50 years or a little bit longer. You know, there's a lot to take care of for the good of the whole. So I think with what we've come up with these the new rules to adopt works best for everybody, and I just wanted to echo about what the science that we've heard from James and from Brian really works best. If we were to inflict any material cost upon the water suppliers who's trying to keep rates stable in order to be able to, you know, with all the growing municipalities around us, with us as a larger water supplier and in the Johnson County area of the big Metroplex area, we are subject to decertification, whereby developers or property owners can opt out. So we've got that to deal with these days, whereby, opt-out means that some pieces of our service area goes to somebody else, or they want to do something else, or drill their own wells. But if we have to deal with that also with added cost through another way instead of what the rules have laid out here, it's really hard to stay on top of keeping rates stable.
Paul D. Perry.
Thank y'all for giving me a moment today. I understand what y'all have to wrestle with as you deal with contesting groups that need a water supply. And water's a big challenge for our state, and it's a big challenge for me as a county commissioner. Locally, although I don't have authority, I constantly hear water issues that are brought to us, and thank you for the opportunity to address you today. I have a couple of concerns. I think you partially answered them, but I want to continue to press these home. My precinct is served by a lot of little groundwater companies that all they have is well water. And that's all they're going to have for the future, most likely. Consolidation is not an option for these companies in many cases. I mean, consolidation sounds great, but when you take one undercapitalized company and you combine it with another undercapitalized company, you have a larger undercapitalized company. I didn't learn much in my career on Wall Street, but I learned that. The other thing is that these companies have a difficult time, and they're dealing with growth in my area. And I will hope that we can be flexible enough in the limits, and we'll look at the proposed rules and see if we need to supplement those rules to make sure those smaller water companies have a larger number that would be allowable for them without jumping through too many bureaucratic hoops. And I'm sure none of y'all like bureaucracy. I don't like bureaucracy. I understand there's a need for monitoring, and I understand we have to share. But at the same time, they need to know what their numbers can be going forward, and with an easy algorithm, an easy formula for them, so that they can deal with it and they can manage for the future. And the other thing in my area, it's still very rural in many parts, and we protect our property rights, as do many of my suburban neighbors. And we need to think of ways going forward where their concerns and their concerns for privacy can be accommodated. People move to the country, they move to unincorporated areas, many of them wanting a little bit more privacy than they would have in the city. And somebody showing up and saying, I'm from the government and I'm here to help you is poorly received enough, but I'm from the government and I'm here to monitor you is even more poorly received, and it eventually can cause more problems than any of us want to contend with. So thank y'all for the opportunity to address you today, and I appreciate what you go through and your own struggles with this. Thank you.
Jay Davis.
I'm Jay Davis from Grandview in Johnson County. I think it's been quite a challenge over the last week for a lot of us to try to absorb these rules and to be prepared. There's been a lot of discussions out there and really concern on what it is going to, the hybrid approach that you're suggesting and what that's going to do to some of our private property rights in the future, and the potential of tiered ownership of those water rights as compared historical to potential future development. But I think it's a lot to absorb. I appreciate what you're trying to do, but we do have a lot of concerns that is being is trying to be absorbed in a very short period of time. I've got some additional written comments that's been presented to me from people through the country that weren't able to be here, and those comments kind of keep coming into me on email. And so, you know, I'm really kind of concerned about the potential of adoption of these rules today, simply based on the timing. A lot of people weren't aware of this, and trying to absorb it and get the news out there to people over Thanksgiving week has been a significant challenge. Thank you.
Joe Palmer.
Good morning, Joe Palmer, Johnson County. Welcome to Johnson County, anybody who's not from here. I appreciate, like the others said before, the amount of hard work this board has gone through to come up with these proposed rules. I've got a few questions, concerns. I guess we're going to ask questions about the data later. I'll go ahead and take my 3 minutes and ask my questions. If you want to provide an answer, that'd be very appreciated. I noticed that the data showing the change in the water table ended in 2010. And every slide that I saw up there, if I'm mistaken about that, let me know. But my question about that is, do you have the data from 2010 till now? And I see people nodding their heads. The significance being that we had record rainfall in 2015. So how would that have affected the water table? And the reason it's significant is, you know, if we're asked to go along with these proposed rules being implemented, it is a guess. The science is there. You've probably spent lots of resources and time obtaining the science, but ultimately we have a guess. But the best guess has to be based on the best data, and the best data is current. So from 2010 to current, we've got rainfall that exceeds the time period that the presentation was relying on. Texas A&M, we got record rainfall in 2015, 77 inches. That doubles the amount of rainfall in the last year of data that you presented in 2010. So I would like to know what the water table looks like right now, or as current as possible. Relating to the proposed rule changes, Rule 1.11, the board has the ability to amend the rules at any time, amend or repeal these rules or adopt new rules. The rules are 140 pages. I know you had notice went out in October, but based on listening to people before me, I'm not the only one who feels like this is a little bit of a surprise. I try to pay attention, but I do not read the newspaper. And I'm not contesting or disputing the notice, but I would like more time to process this. I would like a fee schedule and a fine schedule. I found some alarming numbers, $10,000 fine for noncompliance, and the appeal process or the protest process, I think that needs to be looked at a little bit more. What I would propose is tabling this. I would ask members to make a motion to table until a February meeting or a March meeting for two reasons. Number one is you want buy-in, you want community buy-in. We're here today, I know you're listening to people because you want people to be okay with what's being implemented. I think you would increase that if you postpone to a later meeting and give people time to more fully understand and to meet one-on-one or in groups with you. I have not met my representatives from Johnson County, but I fully intend to now. You've got my attention, right? Other fees, $500, $250 was in there. And rules enforcement, we talked about the 10,000. Rule 1101, the owner of a well is responsible for the installation, operation, maintenance, and repair of the meter associated with the well. What is the projected cost of this over, say, a 10-year period? If the district believes a meter is not accurate, does the district have the power to compel the property owner to pay for a service call or replacement meter?
3 minutes.
You can have mine for a minute, Scott Parks, my name is down.
I don't want to postpone the meeting. We got started 15 minutes late anyway. But anyway, final point, I would really appreciate if you'd postpone. I don't think there's any substantial difference in continuing until a February, March meeting under the temporary rules, which are similar or identical to the proposed permanent rules. You can still operate and function as normally. To me, to my knowledge, there is no deadline that you have to implement these permanent rules today. very grateful for your time. Thank you again.
Thank you. Ronnie Scary?
I don't have any prepared comments, I just have a question or two for later.
Okay.
Thank you.
Cat Parks?
Okay, thank you.
Amy Hetke?
Hi, guys. Amy Hedke, Ellis County, Waxahachie. I wanted to, number one, let everybody know that I'm streaming the meeting, so if you wanted to share it with your friends or family or residents in your community, you can just go to my Facebook page. It's there. It will be there. Easy to share, easy to download. Hedke, Hedtke. But one of the things that I did notice in your presentation is I didn't hear the words dire and immediate and, the sky is falling. And I'd like to suggest that instead of adopting rules today, that you go ahead and hold a public hearing in each of these 4 counties. And don't just hold them at 9 a.m. on a Monday when a lot of people are at work, but have one in the afternoon, have one in an evening, have one on a weekend, and give as many people as possible the opportunity to come and speak and ask questions, so that when you do adopt these rules, you will have pretty much done as much as you possibly can to get community input on these. Because, you're right, these are pretty serious rules. They affect people's daily lives. So that's it from me. Thanks.
Chris Smith?
Good morning, directors. My name is Chris Smith. I'm here on behalf of my client, United States Lime and Minerals. I'm joined by Wendell Smith. Mr. Smith is no relation to me, but he's the environmental manager for the company, which operates the Texas Lime plant in Johnson County. In general, U.S. Lime is supportive of the historic use provisions of the rules, but there is one specific concern, and that relates to the interplay of the proposed well system cap and the individual well cap if you have a well system. Texas Lime has historically operated a well system involving 3 wells throughout the historic use period. Their highest production year from their well system was in 2006. In 2011, one of the 3 wells was stopped being used for production, and today that well system is a 2-well system. The concern that we have is the sum of the 2 highest years of the 2 remaining wells is less than the 2006 production from the well system. So unless there's an exception made for operators of well systems who have reduced the number of wells, there's a possibility that the individual well limit could inadvertently reduce the historic use production limit of that well system. So we'd ask that an amendment be made to address that specific situation. Thank you.
And Rodney Schronk.
Thank you. Good morning. Once again, my name is Rodney Schronk from Hill County. I'm a row crop farmer and a landowner there in Hillsboro. First and foremost, I thank y'all. I realize this is not the most exciting thing in the world that you're spending your time working on, but it's very important. I am appreciative. That being said, I farm, sharecrop farm for 50 different landowners in Hill County. And I deal with Files Valley water, Woodrow Osceola water, Brandon Irene water, and there's nothing more important than our rural water supplies. And I'm very appreciative of the effort that our water supplies put into this. With that being said, as a young man, my wife and I took on the risk of purchasing a piece of property with the hopes that someday as we age, that not only the surface value would be more valuable, but the oil and the water and the gas that might be under or other minerals would become more valuable. And it's a risk we took as an individual. And twice I've heard today say that the government's here to help. And that's what I feel like I'm standing here in front of y'all today. The government's here to help. And have not had time to read through all the rules and regulations because of the short notice. But it appears to me that these rules will allow these water municipalities to come to me and take my water without any financial compensation whatsoever and with very little notice. And that's concerning to me for my private property rights. More so, what concerns me is we're living in a world today where socialism seems to be creeping into our society. Our country was developed on free enterprise and capitalism. And I used to think it was at a distance till I heard this, and it's true. And I'm an Aggie, and apparently English was part of the master's program because I can't read all these things. But if this is true, what I understand is extremely concerning. That the government's here to help and to take my private property rights without compensating me. And so with that, I know y'all have a difficult decision, but I wanted to express those concerns.
That concludes those who had indicated they wish to speak. Are there others?
May I ask a question?
On the hearing side, are there any, is there any?
I thought I was signed up.
Look, I may have, I think it was blank, but we'll put yes down.
Yes.
There was no sign-in sheet when I came in.
There may be others there.
This gentleman, Marty, can verify that.
Yeah, he was here at 8:30 this morning.
Actually, I was here at 8, but I didn't come in until 8:30. So can we ask questions at some point? Okay, that's minor questions. I just want to make sure.
Well, good morning, members of the board. Buck Benson, I represent Martin Marietta. I'm here to provide a few brief comments. Again, I want to thank the board members and staff for the work they've done on these rules. It's no easy task. In general, we are supportive of the rules, but we would like to make a few comments regarding our specific situation. Martin Marietta's situation is very unique in that we had our own water wells that supplied water to our operation. In addition, water was supplied to our operation through another well that we did not own but was drilled on our property pursuant to a license agreement with Chaparral Still. I think it's probably one of the only situations like this in your district. But we want to make sure that the rules as they're adopted allow for us to take into account not only the usage from the wells in our system, but also the usage from the water that was supplied to our operation through the Chaparral Still. Well, I've actually provided the 4 or 5 written proposals to Mr. Slice that y'all can consider. Again, we don't want to affect Chaparral's historic rights to any of their usage, but want to ensure that we're able to capture what we use out of that well as well. I'd like to go ahead and just state our first amendment is to the definition section. Make it clear that we as the landowner that we are the only landowner with respect to those water rights that came out of the well that was underneath on our property. But more importantly, we'd like to clarify in the rules that the well owner can be more than one party. It can include not only us, but Chaparral and us as well for purposes of applying for a historic use permit. That's critical to us, and that we need to be able to both claim usage from that particular well. In addition, we want to make it clear that a party can have more than one well system. Again, in our situation, we had Trinity wells, our own Trinity wells that would supply water to us in one given year, and then we'd use water from the Chaparral well in another given year. So we were using water from 2 different systems. We'd like to make it clear that an owner could apply for his maximum historical use permit based on water used from 2 different systems. I think your current rules just kind of limit it to one system. So again, we'd like that possibility or that potential to include both systems. And then finally, we'd like to add that in the event we have to drill a replacement well, which is not uncommon in our business, that we'd be able to do so and not have to comply with any spacing requirements other than the property boundary requirements. We proposed an amendment to that as well, that basically if we're drilling a replacement well, we can locate it anywhere on our property greater than 50 feet away from the current well, provided we comply with the spacing requirements. Again, we want to ensure that everybody has access to the water and is able to obtain the permits that they need based on their historical usage, and would ask that the board consider these amendments that were provided to Mr. Sledge going forward. Thank you for your time.
anybody else wish to make a comment in the hearing portion of this gathering? Yes.
I have a question. I'm looking on your agenda. You've got a section for questions. Would now be an appropriate time to ask a question?
Yes, sir.
Okay.
We're to that point.
I appreciate your time. One of the gentlemen that spoke was talking about the needs or the wants of the local water districts, not the groundwater conservation district, but the special utility districts and the co-ops and so forth, if I understood correctly. What I would like to know is, have the districts spent any resources on aquifer storage recovery? Because my limited understanding is you've got groundwater, you've got surface water. Those are the two sources of water if you're a water company, right? So our focus is on groundwater today, obviously. But in terms of a water district, looking at long-term providing water to the people, what are we looking at as far as the district's investing money in surface water recovery and also the aquifer storage recovery? Thank you.
The question's on what this district's investing in ASR?
Oh, no, sir. So my understanding is that there are at least a couple of members of the groundwater conservation district that are also involved in the water companies, the water districts. So in that capacity, maybe somebody here can answer the question relating to, the simple way to put it is, what other efforts are being invested in or being focused on to respond to future concerns about water supply, in addition to groundwater and wells?
Okay, I'll try to tackle that because I do a lot of ASR work. But the purpose of this Q&A session is, just for the record, is to talk about questions about these proposed rules. But I'll do that anyway. There's nothing in these rules about aquifer storage and recovery. The legislature overhauled the aquifer storage and recovery rules in House Bill 655 in 2015, which I think is in Texas the most robust ASR program in the nation. And there are a lot of public water suppliers in the Metroplex that I'm aware of, and I can't speak to specific water suppliers or plans, but what that allows is whether they take surface water or groundwater or whatever, they can inject treated water into the ground that complies with water quality standards and pull it out at a later date. And so long as they don't pull out more than they're injecting, this district doesn't have any regulatory authority over them. But that's a program that's administered by the TCEQ, from federal delegation from the EPA. Because our prior law on ASR was hard to believe coming out of the legislature, was so onerous that really nobody in the state was doing it. In fact, I think we counted 3 ASR projects in the entire state when we overhauled that legislation in 2015. But I'm aware that a number of public water systems in the Metroplex, Dallas, Tarrant Regional Water District, Pembroke Water Authority, there's a whole lot of folks looking at ASR as a strategy. Just because you can get more yield out of the same water supplies that you already have typically by injecting water during the winter months when your demand's low, and being able to pull that out by the summer months when your demand's high and everybody's watering their grass. But we don't have anything in these rules about that.
Just one more comment there, Brian. The management plan does speak to the board's objectives on recharge. And so that's one place that
I'll follow up on recharge, and this is really James Bailiwick, because you made some comments on the great rainfall we have, and I'll let James. We do have we've got a very robust well monitoring program and we have readings daily. It's just that the Water Development Board numbers and those stats are typically done on a decadal basis, and 2010 was the last year. But we have those programs, and I can let our hydrogeologists talk about that. But what we do know, we did a pretty in-depth study when we put the groundwater availability model together on recharge over the Trinity Aquifer. In James, it's about, effective aquifer recharge is about 1 inch a year, is that right?
Yes.
The water that actually gets down into the water table below the root zone, the Vados zone, I think they call it, across the district in the Trinity and Woodbine is about 1 inch a year. Regardless of whether, I mean, it's not regardless. It obviously recharges much better in rainy years. It has to be fully saturated and get past all the plants and their roots to get down to the aquifer where the wells are in the water table and in the confining layer. But on average, it's about 1 inch a year across all formations, even if you've got 30 inches on the surface or 70 inches on the surface. And you can see from where we're sitting has the biggest water level declines of any aquifer in any area of the entire state. It's on a consistent downward decline. And there are opportunities to promote more aquifer recharge, but it's tough in a sand aquifer. It's not like in the Edwards where you have a limestone aquifer and it just fills up and empties out, fills up and empties out. The water we're using here is pretty old and it takes a long time to recharge.
Can I understand your statement to mean that the maximum amount of recharge to the water table is about 1 inch a year?
Right.
And what would the maximum rate of depletion, would that also be about 1 inch a year? Or
No, the depletion's greatly exceeding the recharge rate, which is why the overall water levels are just going down, 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 down.
so would you attribute that to drought more or
It's
or
just
well?
pumping exceeds recharge.
Okay.
We got a lot more demand than recharge is providing back to the aquifer, a lot more pumping. Other questions? I know you had some, sir.
Well, mine are pretty simple in a sense. One is, and it's been noted that the notification on this meeting I'm going to call was pretty ineffective. I have a well, I have a permit, I paid for it. I received nothing from y'all about this meeting or the rules. And Marty and I visited with that before the meeting, and I understand you didn't feel you needed to notify everybody that had wells, which to me doesn't seem right. So you took my money for me to be able to drill a well, but then you didn't feel like you needed to notify me that we're going to have a meeting about the effect of my well. And I just don't think that's proper. The other question I have, which you can address, a few years back, the city of Ennis, which is where I used to live, annexed 600 acres, provided no services. So therefore, and I know Ennis doesn't use well water, but if they did, then they've effectively expanded their sphere 600 acres, which now they could use more water. But they provided no water to us, but yet now they can take more water out. So should we not look at what cities and municipalities do as far as whether they're going to actually use that land or they're just land grabbing? Is there any way to have a provision about something like that?
Well, we have no authority over municipal annexation, but obviously there's folks with land inside a retail public utility service area. They're getting their water from a water well instead of from the public utility, and that acreage is assigned under these rules to the individual landowners and not to the retail public utility.
Right, I understand that, but what I'm asking is, the land they took in, they provided no water. But if they were seeking to get water, they could say, we got 600 acres more, so we want more water out of the aquifer, where they've not done anything but take land in. And still have not done anything 15 years later.
There's a process through the Public Utility Commission that regulates those CCNs, where if landowners aren't getting service or have requested service and aren't getting it, you can apply to decertification. We have no authority over those issues. We just have authority over how to allocate that water, and if those landowners are getting their water from private wells instead of from the utilities, then those private landowners are gonna get credit under these rules for that water and not private, and not the public utilities.
Yeah, I understood that, and I appreciate your answer.
Yes, ma'am.
I have a question about the relationship between development and then the time of the water table, and I realize y'all are the water board, but it would seem to me that you could look through your figures and you could determine if the increase in growth of development is what is the cause of the decrease in water tables, or is it just increased growth among people who already exist here? And it would seem to me that there needs to be some sort of explanation as to why it would be okay to take water from the existing people that are here instead of looking at limiting development or placing stricter, something on the developers. Because like the gentleman over here said, is we're looking to stabilize, the water in the municipalities. Well, you're looking to stabilize it by taking it from people who live in the counties.
Well, we don't have any authority over economic growth and approval of developments or plats or anything like that. The county commissioners or the municipal platting authority has jurisdiction over those issues, so it's just not something we have any legal authority to deal with. It is no question that increasing development and increasing population has a corresponding increase in water demand, and that's what's causing the issues with the aquifers. Yes, ma'am.
So I came up with a question, and this is the first I've ever learned of any of this. So when your aquifers are going dry and they're using more than you can replenish, what do other places, what's the next step?
I mean, the next step for this area, in all frankness, is the extension of surface water lines coming out of the Metroplex, which is already occurring in Hill County or Ellis County and coming into parts of Johnson County.
So we are supplementing this with something?
Yes, ma'am. Yeah, the aquifers just, if you look at growth patterns, they just happen in concentric circles coming out of the Metroplex, and we're seeing that in the northern parts of Ellis and Johnson County right now. And the aquifer is just not going to sustain that growth long term. And we do have public water suppliers that are already switching over, part surface water, part groundwater. But you don't want to rush that. Groundwater is a lot cheaper than surface water, and so your average homeowner's monthly water bill goes up when you put surface water in the mix. But it is what has to happen over time, long term.
And until then, like they said, you're going to take from those who've had it and try to spread it out to keep them getting to that point? Is that what you're saying?
Yeah.
Well, I'm not sure what we're taking.
You mean, whenever you put a limit on, okay, now you can use this much and you're permitted for this much, and you're, what did you call it, watching over what they're doing in an effort to make the aquifer last as long as you possibly can?
Yes, ma'am.
Right, so you're kind of sharing the wealth, or trying to share the wealth to make it last as long as you can.
We're trying to manage it on a long-term basis so people's wells don't go dry. And we can't change the amount that the good Lord gave us. It is what it is, and we're at a point in our population density and development that it's getting more than the aquifer can handle. And so what we're required to do by the legislature is to manage it to achieve those aquifer goals that were set. Those aquifer goals, as you saw on Mr. Beach's slide, still have, a couple of 100 feet of further declines in the aquifer, which we could have gone another direction, but tightening it up any more than that would have resulted in less water available for the well owner. So it's kind of a balance you try to strike. But we've heard comments from the public water systems that it's hard for them to make do with the water we've had available, even if we give them credit for acreage within their CCNs. We've heard strong comments out of the Farm Bureau and others that the individual landowners should own those property rights and should have that. And we think we've struck a good balance here by saying Well, if any individual landowner wants to come in and get a permit for their water, we will take that out of the permit of the retail public utility and give it to the individual landowner. But at the same time, those public utilities have a legal obligation to provide service to those homes in their areas, and not everybody, the vast majority of people don't go drill their own well. They just like the clean water that comes from the public water system, and we think we've struck a balance there. Let's hear from the county commissioner first.
Like a lot of newspapers, the paper that y'all gave notice in for us, which is probably the largest circulation paper in the county, has had a circulation drop. Okay? I don't know what that is. It's kind of, I'm sure there's a way to get that number, but they have dropped from daily publication, except for one day a week, and now it's a 3 times a week publication. So my request and question for y'all is can you postpone this in order to give a little bit more notice to the public to the next regularly scheduled meeting after the holidays?
I found out about it day before yesterday on Facebook.
We found out about it last night.
I don't get the paper, whatever it's in over there. And I live in the county and have a water well. Seems like somebody would be able to send something out.
Yes, ma'am, with your hand up in the
I
back.
had 3 specific questions, one from online. What is your deadline for adopting these rules?
We don't have a hard and fast deadline, but we are trying to get them done before the end of the year because there have been measures introduced in the legislature for the last couple of sessions that would remove some of these tools from our toolbox. And there have also been grandfathering provisions in those. And what we're hoping to do is to get the rules passed before the legislature comes to town and grandfather these rules in before the legislature changes the rules of the game. And they come to town the first Tuesday in January.
Okay, that kind of underscores the second question in getting more public input, in that you deliberately wait and let the legislature, who tasked y'all with this in the first place, hear from their constituents and let them decide what tools should be available to you in this toolbox instead of trying to shove it through really quick, kind of going back to get more input. Would that be something that you guys would consider doing and let the legislature, which established y'all in the first place, do their job?
I'm not answering that.
Okay, I guess, well, here's the third one. The third one is going back to the money part. I thought I heard something like $1 million spent or something like that in looking up how much stuff has been done. I don't know how much millions has been invested into what you guys have been working on. It's a long time, lots of years, but considering you've already spent that much money, would it really be unreasonable to address what the gentleman up front was saying and send a simple letter out to the people that you've already taken money for on permitting wells?
That's a budget question, not a lawyer question.
That's why you get the big bucks.
Well, letters did go to those who have non-exempt wells, and I say letters, emails, those folks were notified. They certainly were. Now, on the, you mentioned $1 million amount question. I think that's what either Brian or Mr. Beach were talking about when the new model of the North Texas Woodbine Trinity Aquifer was put together through the authority of GMA 8. There was $1 million or over $1 million spent to develop that model, but that was shared by multiple districts in GMA 8. So it was a GMA 8 project. And it was then later proven to be the best model available, and Texas Water Development Board did adopt it as the official model for the Woodbine North Trinity aquifers in the state of Texas. So that takes care of the dollar question.
And when you said non-exempt, how many non-exempt versus exempt wells do you have?
I know we've got over 500 non-exempt. Stephanie, what do we have on the exempt? 600 or 700.
Now, those 600 or 700, are they going to be affected by these rules at all?
Very little in our opinion. Those are the household, domestic, and livestock that we will put 17.36 and under, and they're going to be affected very, very little.
Very little bit, they should probably read that part of the rules where they are affected.
I mean, they're really not affected. It's the exact same thing as the temporary rules. Yes, sir.
My well produces a lot more water than that, but I don't use that much water. So where do I fall? I mean, I drilled a well. I didn't tell the company that drilled it I want to produce less than 17 gallons. I said I want to drill a well, and they came out and drilled it. Then they told me how much it produce. So I can produce way more than that. So am I affected or not affected?
You're not, for a household well?
Well, it's on my property. Have 60 plus acres. Got 20-something cows.
You use it for livestock or for household purposes?
Not household, no thank you.
Domestic purposes, just livestock, watering your grass?
Yep.
It's exempt.
Okay. Thank you.
Yes, sir.
So in this scenario you're talking about, because it kind of affects us, are we going to need to be metered to be able to read the usage of our well at all?
Not for a household well or a livestock well or anything like that.
Okay.
Okay.
We're here asking for our neighbors as well.
Yeah, and I want to explain that and respond to Mr. Schuler's comments. You know, the vast majority of the wells in the district are household type wells, livestock wells. We didn't ever want to get into the business of having to permit those, put a meter on them, collect fees from them, any of that. And so, what we have is the 2 acre minimum tract size requirement. If you had small, that's already in the rules. That's been there since, I don't know how long, but a while. If you had a 1 acre tract that existed prior to that rule, that's grandfathered. You can still get well on it. But we try to drop that minimum tract size to just let those folks self-regulate. The idea is put them on enough acreage where the typical amount of use that folks use for livestock or household or watering their grass or taking showers is covered by the amount of land that they have. And so the comment that, well, if we ran those wells 24/7, 365 days a year, they'd use all this, but they don't. They don't. We know that the typical retail connection from, I think the Water Development Board's number is typical retail connections, 89,000 gallons a year. It might be up to 100 or 120,000 gallons a year, but it's not, and we don't have enough. We don't want a big brother coming out to police everybody's household wells. And it's a drop in the bucket compared to the amount of water that's used by the big wells. And as I noted earlier, the big wells that are everything we've talked about, we get about 10 or 12, if that, wells drilled in all 4 counties in a year. So you'll know if you're one of those. You're a big public water supplier, or, you know, we've got big steel companies and aggregate operations here. Those are the wells we're talking about. The other ones, we are keeping our nose out from under your tent. Because you don't have that big of an impact. Yes, sir.
With regards to that differentiation between exempt and non-exempt wells, and then the CCN service areas and claiming those properties, we've got the case in Grandview where Johnson County Rural Water Supply doesn't have the infrastructure to service the new developments, even though they're within the CCN. And so you've got the exempt wells being drilled. Is that gonna be double dipping?
No.
In terms of the use of the water in those areas? Because Johnson County Rural Water Supply is gonna claim it, and then it's gonna be on an exempt well.
No, we take that acreage associated with those exempt wells out of the acreage that they get credit for in the CC. Yes, ma'am.
A real quick reference question, can you share for everybody where in the rules it defines non-exempt and exempt, what page number maybe?
I believe it's in Rule 2.1. I don't have the page number on it, but they're in numerical order. Yes, sir.
Yeah, I struggle with the, your definition of well system on how it applies to us. Mineral water supply, we've got one distribution system, but it's in two different groundwater conservation districts. And we've got a well in each of the two groundwater conservation districts. Okay? So what is your well system in our case? You understand? One system, one distribution system.
Stump the prof, right?
We've got one distribution system. We call it, and if we have part of the distribution system, most of it's in Hill County. Some is in McLennan County. We have one well in Hill County, one well in McLennan County under the Southern Trinity Groundwater Conservation District. So on your definition, what is a well system? Is it only the system of the one well we have in Hill County, or does it include?
For you, it's just the well that you have inside our district.
That's what I thought, but
we don't have any authority over the well in McLennan.
That's what I thought, but I just wanted to.
Yes, sir. Terry's been waiting, let's hear it.
Let me just offer some information that might help address what your concerns were and what the question over here about growth. Johnson County Special Utility District, 25 years ago, we were providing 100% of the water. Today, 2018, within the 19 years, that's 30%. So that percentage continues to go down over the years. We've developed surface water supplies. We get water from Lake Granbury and from the city of Mansfield. So in a large way, the growth that comes onto the system, we're trying to develop more of surface water sources and less of well water. We don't have any plan to drill any more wells, and most of the larger rural water suppliers and the cities are weaning more off of the wells just to be better stewards, knowing that we need to take care of and develop the surface water where you might not understand that we're still supplying 100% well water. That's not the case, and I thought that might help us to understand that we're looking to mitigate the issues with the depleting supply of our groundwater by developing the surface water. So 70% of that in the prevailing way serves the growth and the people that are here today.
Thank you. Yes.
So it's brought up again, and I appreciate it being brought up, about surface water versus groundwater. So you represented the water utility, special utility district, Johnson County. Have you or have the other districts looked into maximizing output from surface water to such an extent that you can leave the groundwater issue the way it is, where you wouldn't have to pull more water out of the ground, but you can develop the surface water?
You mentioned ASR, and we've looked at that very closely. And that, you've got resources, or we've got our natural resources and the resources that we, in dollars, to take what makes sense in a practical way to do what we do, to try to balance what surface water sources we have, and also we still have to utilize the ground. We just can't wean off of the groundwater sources, and the ASR management strategy just doesn't work for the majority of us. And I'll give you a quick example. That is where you're buying that water from or treating it. You treat the water, and then you're spending that, whether it comes from the city of Mansfield or over reverse osmosis water, desalinized water from Lake Granbury. Whenever you pump that in, you've got to develop upfront costs to get that into the ground. And then you've got that transmissivity that's going to allow the dynamic
somewhere. Some of it will stay there with you, but you've got that cost to pump it back out. So whenever you look at all that, I'm just trying to give an overview of it. It just doesn't work economically to try to create this balance of the cost of the water and what works best with which sources you draw from.
So it would be more expensive to maximize production or processing of surface water. That would be a more expensive option than groundwater, than increasing groundwater control.
Categorically speaking, surface water is always going to be more expensive.
Okay.
Whether it's throwing the hose off into the ocean, which is the ultimate thing, it sounds like, gosh, there's lots there, all we gotta do is treat it and send it.
Yeah.
But there's just so much cost involved, even with that end of the spectrum, with using ocean water versus ASR that's somewhere else in the middle.
I think there's a little bit of a difference in the way this is being viewed, because you're making extremely valid arguments on the cost aspect, that it's more expensive to produce surface water than it is to deal with groundwater. But there are others who are looking at it from a property rights issue. And I guess the question I would ask you is, would that change your view of it if you looked at it not only from a cost view, but also a property rights issue? Because, you know, if I'm looking at wanting to punch a well, and I'm looking at it here, and I'm looking at giving the authority to a local entity to put a tag on the meter, and that be for drawing water, it's not an economic argument.
I think got a response for that right now, and I know we're drifting further away from what the scope of the work is.
So, one last question. I'm looking at Rule 8.3 regarding the tagging of wells, and it says the well may be tagged to indicate that the well may not be operated by order of the district. The district may recover costs incurred for tagging the well under this rule from the owner of the well. Other appropriate action may be taken as necessary to include operation of the well or to identify unauthorized operation of the well. And 8.3b says the owner of the well may appeal the decision of the board or general manager to tag the well by filing a written request for a hearing before the board, in which case the board will hear the owner's appeal at the next regular board meeting, for which notice has not already been published. I'm worried about the length of time that could occur between the well being tagged for whatever reason and a hearing that will allow the property owner to get the well turned back on. I know this isn't something that's going to happen every day, but when it does happen, or when it could happen, you know, what about the property owner who has livestock or who relies on that water? Should there be a provision for a special hearing or a special meeting in the instance of an emergency like that?
The well tagging provision doesn't apply to household or livestock wells.
I'm talking about the wells that this rule does apply to, not the rules that, not the household, not the wells that it does not.
And a tag doesn't actually shut the well off. A tag's a...
Other appropriate action may be taken as necessary to preclude operation of the well. That's 8.3b.
I just don't see that under 8.3.
Inspection and enforcement rules.
I'm sorry, that's just not lining up with either the current rules or the proposed rules that we're looking at.
I've lost it, and I'm looking for it.
I have a question, meantime. So as the water levels decrease, there are other counties other than the four counties that are responsible for that decrease. Is that correct, in some of these aquifers? So what happens?
I'm sorry, did you repeat the question?
Yes, sir. There are other counties who access these aquifers who are not included in the Ford County area, is that correct?
Yes, ma'am.
So what happens when those other counties don't have anything in place to regulate their own water use? Will people of this county with water fees be penalized for use from other counties who are in the same aquifer?
All those other counties, districts have the same mandate we do. They have to achieve the desired future conditions that were set on a regional basis. And if they fail to do so, there is a process for the TCEQ to deal with it.
Can you tell me how many of the counties that are in our, G8 or whatever it is?
54.
54? How
Or
many
45. Am I being dyslexic?
45.
45, I had a dyslexic moment.
Those are all the ones that have a water district, or some of those do not have a water district?
Some of them do not. Dallas County does not have a water district. There's a
sporadic group towards extra county that don't.
Yeah, up on the Red River.
When we're looking at these water levels going down, wouldn't Dallas and Tarrant County, who do not have water districts?
Tarrant County does have one.
Tarrant does?
Yes.
Isn't Dallas County probably a large consumer of?
Dallas County hadn't created a groundwater district because they have very little groundwater pumpage.
Okay,
They're mostly all on surface water now.
thank you.
Yes, ma'am.
One other thing I want to mention is that the concern over the non-exempt wells, and we don't have that many people come in and want those per year. We're on these new rules, we're estimating 7 to 10 a year. But on that process, that's going to require a pre-application process where we sit down with the applicant and go through their needs. What do they need in the way of groundwater? What aquifers are they looking at? Will most likely all those wells will have a consultant engineer connected to them. They'll be mainly in public water supplies. But we'll walk them through, and then prior to those permits being granted, there will be a public hearing on that particular well each time before the board of directors. Also, we will look at the neighboring countryside, the neighbors to that well. And those people will be notified of that hearing. We're required to give a 20-day notice by law, so they'll have at least a 20-day notice. So for those 7, 8, maybe 10 wells a year, it's going to be a tougher, a little bit process. But I think as much as they would pump, we would want to go through that, give the neighbors a chance to review it, and it'll be, those only can be approved at a public hearing.
Can you read the definition of a non-exempt well for everybody that hasn't looked at the definitions yet?
It's a long definition.
Well, you spent 10 years on it
Is the definition shorter?
Wells exempt from permitting, water use fee payment, metering, and reporting requirements. All wells, existing or new, of any size or capacity, used solely for domestic use, livestock use, poultry use, or agricultural use. An existing well that's not a public water supply well, that doesn't have the capacity, is equipped to produce more than 25 gallons per minute, and is used for any other purpose besides domestic use, livestock, poultry, or agricultural use. A new well with a maximum design production capacity of 17.36 gallons per minute or less, used for any purpose use other than public water supply, and leachate wells, monitoring wells, and piezometers.
these rules will have there's a high likelihood that they'll get more onerous if this spills over into the new year? And the legislation,
Well, the two things that have been threatened at the legislature the last two sessions have been removing our ability to protect historic users and removing our ability to give public water supply any credit for the acreage in their CCN. Those are bills we've seen introduced the last couple of sessions that have gotten some traction. And they are promised to be reintroduced this session. And we really don't know how we could do this without having those two tools on the toolbox. So we're kind of anxious to get it done. Other questions?
You're saying there are legislative concerns that maybe the next legislative session, which begins in January, might make it more difficult for us to implement these after the session?
Yes.
Okay. What is the substance of that? Or was somebody elected who is an ardent opposer to what's being proposed here today, and they found to file a bill to stop what we're trying to do? I mean, all I know, this is my limited understanding, is the Republicans still control all relevant branches of the state government. They lost 20 seats in the House, they lost a couple senators, but by and large, you're going to have the same political ideology and control of this legislative session as you did last session. So could you give specific examples of why it is that you believe this upcoming session is going to make it difficult for you to implement these rules?
I can give specific examples. Yeah, we had bills introduced by the chairman of the Senate Water Committee, who's probably positionally the most powerful man in the Texas legislature on these issues. He is not a fan of historic use protection. He's not a fan of allowing retail public utilities any credit for surface acreage in their CCNs. And we had a House committee chairman that didn't necessarily agree with his opinions on those issues, but we have a new speaker at the House, and we don't know who the House committee chairman is going to be, and we don't know if those bills are going to sail right through both chambers or not.
So it's uncertainty. It's not a concern that it's going to have a worse chance. We just don't have any idea either way.
We don't.
Okay. Well, that's different from thinking that the upcoming legislature is going to be less cooperative than the last one.
I wouldn't call either one of them cooperative, but
They're elected officials, we know better.
just depends on the issue and the stakeholder typically.
So to be fair, you have uncertainty going into any legislative session, not just this upcoming one.
You always have uncertainty going into a legislative session. Other questions? Well, we appreciate you attending, and if you've got other follow-up questions, I think, yeah. And at that, I'll turn it back over to El Presidente.
Thank you for all the questions. At this time, 11:15, the board will recess to close executive session under section 551.071 Government Code to consult with our attorney on issues on today's agenda. No final action will be taken in closed session. At the end of the closed session, the board will reconvene in open session. And we'll take a 5-minute break.